Do you have the paperwork? Oh, you're bringing it, something. What's my date? 28. Court does call the case, people versus Joshua Wara.
Trevor Mabel for the people you're on.
We are ready in this matter. Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Wara. Mr. Wara, state your name for the record.
This one's a wild ride from start to finish. A man accused of a hit and run causing serious injury insists he's perfectly sane and that the real culprits are the Ku Klux Klan and AI hackers. The judge stays calm, the prosecutor stays ready, and the courtroom slowly unravels into chaos. But the big question, is Joshua Wara competent to stand trial or lost in his own conspiracy? Let's break this down.
Joshua Wara.
All right.
Against Lauren Brown. That's perfect. That's perfect.
And this is a date and time I had set preliminary examination in this matter. My understanding is you would like a forensic evaluation.
That is correct, Your Honor. Based on my conversations with Mr. Wara.
Forensic evaluation for what? What's going on here?
Based on my conversations with Mr. Wara, I believe that it is necessary.
Hey, I'm representing myself. What are my charges? What am I in here for? I'm representing myself. I don't need a barcode to represent myself. What am I in here for? What charge am I on here for? I don't need a forensic exam. I'm not mentally disabled. I have ADHD and PTSD. I'm perfectly fine. I'm not on Social Security.
Sir, you are before the court on a felony complaint that alleges that on or about, as I read to you before, October 15, 2025, location of South Main Street and East William Street in the city of Ann Arbor, Washtenaw County, state of Michigan, that you did fail to stop at the scene of an accident resulting in serious impairment or death. Individual.
The guy was
That is a
perfectly
felony.
fine.
That is a felony, punishable by up to 5 years incarceration and a $5,000 fine plus court costs. You do understand that, sir?
I understand that. Thank you,
All right,
Mr.
count
Simpson.
two on that complaint alleges that on that same date and at that same location that you did commit a moving violation causing serious impairment of a bodily function. That's a misdemeanor, punishable by up to 93 days, $500 fine plus court costs. You understand that?
Yeah, I understand that.
All right. So that is what you are here for.
Mr. Simpson, I'd like to subpoena the camera footage from the mobile gas station there on North Main Street that I was at, or on South Main Street where I was at, over on South Main Street in Maynard. My car was parked there the whole time. I accidentally hit the guy. They hacked the light using an AI.
So, Mr. Warren, I'm going to suggest to you this.
App.
When a defendant insists on representing themselves, it's called pro se representation. Judges allow it, but it's risky. Joshua's already showing confusion, mixing mental health with legal competence. ADHD and PTSD don't necessarily make someone unfit for trial, but the judge has to make sure he actually understands the charges and possible penalties.
App. The Tomboys and the Ku Klux Klan, and they had broken my glasses when I wasn't. They took my car for a joyride and broke my glasses while I was at St. Joe's Hospital.
The Klan did?
Huh? Yeah, the Ku Klux Klan. You can subpoena video records, and I subpoena the security guards from St. Joe's Hospital, Trinity Hospital.
That's one of the reasons why you have an attorney. Did you let them know that?
No, I don't have an attorney. I told them I don't want anybody to represent. I said I'm representing myself. Yes.
Is that what you want to do?
Yes, I would like to do that.
Sure.
And I would like to subpoena the camera footage from the gas station.
What the charges are, sir. That if you elect to represent yourself, you'll be held to the same standards as an attorney would regarding the rules of evidence and procedure in the courtroom.
Yes, Your Honor, I understand
and
that.
not be shown any favoritism.
Yes, and I would like to subpoena my discovery packet, please.
Time you wish then to be represented by counsel, you need to make that request to the court.
Okay. I've
To-
tried calling the public defender's office and I've tried to tell them I want to represent myself. And I've tried to subpoena my discovery packet and they won't bring it to me. I need to subpoena my discovery packet for all cases available, please.
All
And I would like,
cases
yep.
only
And I
have
would like to
one. You have
also
more than one?
subpoena everybody's address in the MDOC that's involved in the Neuralink case through Secretary of State, phone numbers, text messages, and visual voicemail records. And I would like to subpoena the phone recordings, secures GTL recordings from when I was in the MDOC at ARF level 4 and WCC pictures and
Sir, I listened to you both through the last hearing and this hearing. So what I'm going to do at this point is I'm not going to relieve the public defenders, but I am concerned, while you have indicated to me that you don't need a forensic evaluation, the court, in listening to you, does believe that you would need a forensic evaluation.
no, I'm perfectly
your own-
fine, Mr.
sir?
Simpson.
Sir, for your own
I'm not on
protection
Social
and
Security.
preservation of your rights.
I'm not on Social Security. I'm over the age of 25. I'm not mentally disabled. I do not need a forensic.
And sir, here's the
Investigate.
thing.
I do not
I
go
have
to the
to,
forensic
Wait,
center.
did he just say the Ku Klux Klan and AI hackers controlled the traffic light? That's the kind of statement that instantly triggers judicial concern. Remember, the judge isn't mocking him. She's assessing reality. If a defendant's explanations drift into delusion, the court must consider a forensic evaluation. It's about protecting his constitutional right to a fair trial.
Forensic center.
I have to, in terms of these proceedings, make sure that you are competent and
Oh, I'm very
No-
competent, Cedric Simpson. You can tell. I'm very intelligent. I have a GED. I got a GED in 2013 in 3 months.
All right.
I got a GED from Washington Community College Adult Transitions Program in less than 90 days in 2013. You can subpoena that record. If someone can get a GED in less than 5 months, I'm pretty sure they're competent.
Not really.
And I would like to
Well,
subpoena my GED from the Adult
you
Transitions
can
Program
do
in
that.
2013 at Washington Community College.
Subpoena. I will not relieve the public defender at this point, but I will consider certainly that once the
Thank you. Yeah, that way,
Forensic
if you see I got a GED from WCC in 2013 in 3 months, you know I'm competent. You know what I'm saying? Thank you, Judge.
I am going to order a forensic evaluation. I will set a competency hearing just to make sure. I'm going to set that for January 29th, 2025,
January 29.
a.m. I will sign an order to
Can you give me a
the effect
PR
that
bond, please?
I'm sorry.
Can I please, I would like to request a PR bond.
This time you can file a motion or somebody can file a motion before the court and I'll consider a written motion, but at this time I'm not going to change the bond in this case.
What is the bond?
Currently, your bond is set at $25,000 cash sure.
Do you have any bail bondsman numbers for me that I could get a hold of, please?
Sorry,
I'd like to subpoena a bail bondsman.
You can check with the individuals at the jail. I'm sure they'll be more than happy to assist you in that regard. All right. So that you understand, I'm leaving the public defender on the case at this point.
No, I don't want a
Get
public
the
defender.
evaluation. I hear you, but I'm telling you what I'm doing. We will get the evaluation. I'd suggest that you be cooperative in that. You may be right and come back competent, and then we can get this proceeding moving even quicker.
Not gonna come back, huh? I was gonna try it.
Before we go off the record,
Y'all corrupted it. Y'all fucked up, people. Y'all people fucked up. Y'all.
Okay, keep moving. All right, been a pleasure.
I'm Benjamin Franklin's son.
Me too.
Joshua's requests are spiraling. He's now trying to subpoena state phone records, MDOC staff, and even something called the Neuralink case. But a subpoena must be specific and relevant. This kind of scattershot demand shows why the judge and his own public defender are pushing for a competency evaluation. It's not punishment, it's procedure.
I just want to.
Because Paris is lovely in this one.
I just want to address one thing, Your Honor, relating to the prosecutor's office's responsibility of providing discovery as we move forward in this case. The defendant, in attempting to represent himself at the PCC on Thursday last week, stated that he didn't need an attorney, he didn't want an attorney, and that he didn't need the discovery either, that he knew what was going on, and that he wasn't worried about having all the video prior to today's hearing, and we prepared to proceed today. At the same time, under normal circumstances, we would be in the process of getting all of that video discovery to defense counsel that he referenced wanting today. He mentioned wanting the video at the intersection. My office is in the process of getting that hopefully before the weekend. And I'm looking for permission to provide discovery to Mr. Brown's office on this file moving forward.
In response, Your Honor, as we are still on the case, I would ask that they provide discovery as they normally would.
And then if in January, depending on what happens, then certainly that information can be tendered either if he's going to represent himself, which he may be entitled to do, then the public defender can turn it over to the prosecutors we have in other cases and supply it directly to him.
Understood.
All right. Thank you.
Here's the turning point. The judge orders a forensic exam, standard when competency is in doubt. Joshua pleads for a PR bond, meaning release without paying cash, but the court denies it for now. Why? Because if he's not mentally fit or may not return to court, releasing him could risk public safety and his own well-being. This is classic judicial balance between compassion and caution.
At least I wasn't called the Illuminati. Well, that's also called a bunch. It was also called a bunch of other things, but that's okay. I'm good with that. I'm confident in me. So is that your only case, Mr. Brown?
I think it's so long.
Court calls the case of the people.
Court does call the case. What's your names?
Lori Anderson. Ronnie Martin.
All right. We're here today for a decision on this case, but I'm a bit confused about one thing. Ms. Anderson, you filed a new case for non-payment?
Yes, that was just to make sure for,
Make sure of what?
she hasn't paid, September, October, or, rent, so. I was told to file a 7-day.
Did you put September in escrow? This Friday. And then what about October?
I'm going to get that in as soon as possible as well. I don't have a date.
So
I thought I was supposed to,
what?
sorry.
What did you say?
I thought I was supposed to since she was late for rent for 3 months.
Well, if I render a decision on this case, something's got to be done with that one because this is a non-payment also.
Yeah, it is, sir. I'm sorry.
When is that set for?
As the hearing ends, Joshua lashes out, shouting at the courtroom and claiming he's Benjamin Franklin's son. It's sad but revealing. The judge's instincts were right. Forensic evaluations aren't insults. They're safeguards. The system pauses to make sure the accused truly understands what's happening before proceeding to trial.
That's the 8:30 hearing.
Yes.
My date after that is in what? No, no, this for Tuesday. So here's what I'm going to do. That case, have you been served on that case, ma'am? A new one?
So, yes.
To come to court on the 7th?
Yes.
All right. I don't know why that was done, but it's now caused a bit of confusion. It's procedure. Yes.
I thought I was supposed to when it was late. I'm sorry if I made a mistake, but
Well, there's an escrow order that's in this case. And you went through a whole hearing on this case.
Yeah.
And I'm going to render a decision, but that other case is outstanding. So what I'm going to do is I'm going to let that proceed on the 7th. I'm going to adjourn this case to my decision on this case to November 18th to allow that case to catch up because I don't want a stray case out there. You have the option if you want to, I'm still adjourning this one out to that date, but you do have the option that what you can do is you can dismiss that other case because I don't know what you would get out of that case that you wouldn't get in this case.
Can I dismiss the,
I don't have it in front of me. I don't even know where you filed it.
can I dismiss this case and just go with this one on the 7th? Since it's for non-payment of rent? That's what I prefer to do.
I'm not going to relitigate this whole case.
I just
That's
want,
what you want to do.
no, I just want to do it for non-payment of rent. I can dismiss the,
Well, she's got some counterclaims. You want to just dismiss this case and just go forth on
Might as well keep going. We've been here since June, so I just.
Oh, I know.
I mean, there's also an outstanding water balance of almost $1,500. So I would just rather cancel this case since I'm the plaintiff and then just go with the 7th.
The water bill she mentioned, she took the water bill out of my name and paid it in full.
It was due on the 6th and they said it would go on my tax bills if I didn't pay
I
it.
don't
So
know
I
why
paid
I'm
it.
talking about a water bill at this point.
Sir,
What do you want to do? Because you've got this thing all over the place.
I'm going to withdraw this case and just go with the 7th for non-payment of rent. She's 3 months behind right now. And the water bills,
How can she be 3 months behind? She's
September, October, and then it'll be November, and then the water bill of $1,500. So it's well over, she owes a total of $15,000, a little over 15, and she has 6,600 in escrow. So it's getting deeper and deeper. The further we delay it, the bigger the hole gets.
I'm not delaying anything. You keep doing stuff.
I want to cancel, I want to call this one and just go for the 7th since I'm the plaintiff on both.
Next up, a totally different kind of drama. A landlord-tenant dispute that spiraled into confusion over rent, escrow payments, and multiple overlapping cases. Judge Simpson must now play referee between two frustrated sides. After the chaos of the last hearing, this one's all about procedure, paperwork, and patience.
For non-payment of rent, that's all I'm concerned.
No, I know. That's why I don't understand the second case.
Well, that's all I want is to pay
I mean,
rent.
you think I'm sitting up here and don't know anything.
Yeah.
I look stupid, but I'm...
No, you're very smart, sir.
Oh, I know that.
I would just rather withdraw this case and just go on with the 7th.
You let me know when you're done talking.
Okay, sir. Thank you, sir.
Are you done?
Yeah, I mean, the other attorney,
You're not. Go ahead.
the other attorney I was working with before suggested that I do that I withdraw this case and just do the 7-day notice. That's what he suggested. He said that would be easier.
You done?
Yes, sir.
Lyman, what would you like to do? So just so that you understand, if she dismisses this case, what I would do is I would pay the escrow over to her, okay, on this case. Now, no, if you dismissed it, I would be dismissing any of your claims that you have against her. Any of them with prejudice, you'd be able to raise them in the other one if that's what you choose to do. But that's up to you. And then you'd have to come back on the 7th and we'll see exactly where we are.
I just feel like we should just keep going. We can go this way.
But
Finish it out.
since I'm the plaintiff, don't I have the right to cancel that one, listening to my counsel?
You should have gotten an attorney before you started. But
I know, but that's what he suggested I do. He said,
no, because once she's answered, she has the same right. She can say no.
okay. So if I cancel the one on the 7th, can we just be done with this today? Is that better? I just don't want to keep dragging this on. So if I just kill the one for the 7th and we just,
Ma'am, I can't give you.
well, that's what I want to do.
as to, well, I don't have that case in front of me. It hasn't even been heard. It was filed.
It was just for non-payment of rent, but since you said it overlaps this one, then
This second case is pure courtroom clutter. Duplicate filings, unpaid rent, and a water bill big enough to drown a small city. The judge finally steps in to synchronize everything. Smart move to prevent double litigation. What's the takeaway? Whether it's a felony or a landlord fight, clear procedure is everything. If you found this courtroom roller coaster as fascinating as we did, hit that like button, share your thoughts in the comments. And don't forget to subscribe for more real-life courtroom breakdowns that reveal how justice actually works.
Then let's just cancel that one and just do the non-payment of rent on
That's
this.
what I'm gonna do. You're gonna stop talking,
Okay.
and then I'm gonna do what I was gonna do at the beginning. And that is, I'm gonna let that other case catch up. They're just gonna be together because you elected to file it. Under what reasoning, I'm not even concerned about that. But I'm not gonna have two cases standing out in this situation. So I'm adjourning this case for its decision to November 18th. When we get to the other case on the 7th, I will try to have that case catch up with this case, and then we can just decide everything, unless somebody wants to file something else in the end.
Thank you.
What time on 18th?
9.
Are we coming on the 7th as well, sir? Okay. Thank you.